he talks about, he kept referring to another NRS statute that doesn't exist.
Blandino versus Nevada Department of Probation, case number 824-907-619.
Kim Blandino appearing pro se for Kim Blandino, Judge.
All right, this is against the Probation and the Attorney General here. My name is Michael Schwartzer. I'm with the state Clark County District Attorney's Office.
I'm sorry, he was mumbling. What did he say about the Attorney General? Could he repeat that?
He said that if PMP is a defendant, probably the Attorney General's office should be.
Yeah, I think that's more appropriate as well, Judge, in all honesty.
I don't know if they are even aware of the case. But it's all right. We're going to hear it today.
Okay,
There's
good.
an emergency motion for relief under NRS 3.026 and EJDC Rule 1.30 from me as Chief Judge in my administrative capacity. I've read the pleadings and I'm happy to hear whatever argument you have.
Excuse me, Judge, point of correction. These aren't, I mean, you could say these are pleadings, but technically it's a motion. This is a collateral proceeding to the ongoing petition. So I guess you could call it pleadings, but oftentimes I find that judges and lawyers call motions part of the pleadings, and they're motions and other papers, and the rules of civil procedure, both Nevada and federal. It's clear there's a distinction between pleadings, motions, and other papers, such as errata, affidavits, and so forth. Matter of fact, Alex Falcone, who has graciously been here with our Nevada judges, got a reversal on that very point that something was stricken with what was called pleadings, but it was really motions. In any event, to the motion, I want to point out that there was a reply filed by me. There was a response, if you really want to call it that, or opposition. It doesn't really oppose any of my main points of relief I'm asking for. The relief, which I'm going to go to first. I'm requesting that the Nevada Supreme Court assign a judge from another district. That's number one. I left out the first part, credit to that. I ask that in your administrative capacity, you do the following things, which Judge Bell did in the Marlon Brown case, which I cited and gave an exhibit to, when it was possible that the Judge Leavitt then, in that case, could be a potential witness in the habeas case, and a judge from another district was assigned by the Nevada Supreme Court. And then to another judge, another district, to continue in my post-conviction case. 2, to report the above violations of the code and law by Leavitt to the Nevada Commission on Judicial Discipline and refer the criminal violations to state and federal law enforcement, especially for keeping Kim out of the Leavitt courtroom. 3, report Leavitt to the Nevada Commission on Judicial Discipline, which you have an obligation under the code under Rule 2.15, which has been enforced by the commission. And Judge Hopkins was neglectful in not reporting misconduct by then Judge Ramsey of North Las Vegas to the commission for violations of the code. So you have that ongoing duty. If you have information that the code's been violated, you have an obligation to report it to the appropriate authorities. To report Leavitt to the commission for failure to issue a written, signed, and filed orders regarding the outstanding motions in case C18-334876. Then 4, to find, as Judge Bell did, that Leavitt and other district court judges will likely be called to the hearing as witnesses supporting the request from a judge from another district. To establish and publish in appropriate place the procedures for filing grievances in conjunction with the mandate of NRS 3.026, so individuals and or parties can follow procedures for filing grievances against the judge that does not address the merits. To this point, I did bring this, I had found it just this morning. Judge Gonzalez, when she was chief judge before it turned over to Judge Bell in 2018 or 2019, I sent this to this customer feedback in, and Judge Gonzalez had the nerve at that hearing when she found me to be a vexatious litigant ultimately, that this was what was done under 3.026, these customer feedback forms, which is laughable. Because if you're going to set up procedures for complaining against a judge in your case that's not merits related, but related to maybe some code violation or some other type of rule violation, and the chief judge can step in and say, hey, wait, what are you doing? You may not have been around when the Halverson-Hardcastle thing went all the way to the U.S. Supreme Court, and a 3-judge appointed panel by the chief judge, and the chief judge Hardcastle and 2 other judges that tried to reason with Judge Halverson, who was totally gone off the rails and was just acting bizarrely, ultimately gets removed by the Commission on Judicial Discipline. And then, so if there's a procedure you establish, then first and foremost, if you're my judge in a case, as is this instance right now, and you do some code violation or rule violation, you obviously couldn't hear the grievance about yourself. That violates all notions of due process. Therefore, you would have to establish a procedure whereby, if you were the judge in that case, would you assign a lower judge in the same district, or maybe a judge outside the district? The legislature thought this was important. They went before both houses, Senate and Assembly. The governor signed this, and it's been completely ignored. This customer feedback I sent here, this was about Judge Bell, and this has numerous exhibits. This isn't just bare allegations. I mean, this is customer feedback, plus I attached numerous pages. And then go on to tell Bell, coincidentally, that these acts of keeping me from the courthouse without being forced to wear a mask or take a vaccine was criminal. Judge Cherry, who was settlement judge in the criminal case at that time, I was outside the courtroom, ready to come in on the settlement conference, and he said, no, you gotta wear a mask. I said, I don't think so. You get a hold of Justice Cherry. And Justice Cherry had the bagels escort me up into the building while everybody else was being required to wear a mask or vaccine. And I was in a settlement room where it was a chambers, a courtroom they weren't using at the time. And so we had the district attorney, me, my standby counsel at that time, Justice Cherry, of course, and then the district attorney, Michael Dickerson, and Melody Marland, and we were trying to negotiate a settlement. And it was there that's part of the issues that I have in the underlying habeas on this. But I wasn't wearing a mask. Nobody was fearing their life. As a matter of fact, this court can take judicial notice if they wish on my word that I never wore a mask, I never took the vaccine, and never got COVID. I was tested. Part of this was the fact that I introduced tests, exhibits of COVID tests of August 2021, health, negative, August 31, 2021, lab test. That was with one of the labs here in town. So I did an actual blood test to try and allay any of these chicken little people. The sky is falling. Exhibit 3, COVID test of November 8, 2021, negative. And so I was introducing all this negative evidence. I got no response back to this. So if you establish procedures as you must under the law, then part of those procedures has to be that you have to get some kind of response, yay, nay, or, well, I don't know, let's bump it up to another court, or whatever it might be. But I would say probably conservatively, I get responses to these maybe 5% of the time. The Timothy Andrews response that I put as an exhibit, you saw that, where it said that there is nothing currently preventing me from going into Leavitt's courtroom, when I clearly stated under penalty of perjury that she and Randy Hawks had kept me out of the courtroom after I had completed my probation, which is a violation of my civil rights, a criminal violation. Timothy Andrews only addressed it going forward, doesn't address anything going backward. And I can understand that he would be hard-pressed to do anything like that. However, and you will recall that I caught you in a break, and I told you about the Leavitt stopping me from going into her courtroom, and as you said, Mr. Blandino, you're going to have to file something. And then I said, well, I'm a vexatious litigant. I don't want to be accused of filing something vexatiously. And the reason, as a matter of fact, I didn't file leave to file this particular action is that Leavitt said, you can file whatever you want before Judge Wiese. I'm referring it to him on the transcript. Up until that time, the vexatious litigant order didn't say anything about the judge in the case being able to allow me to file things. It became an issue. I took it to the Nevada Supreme Court, and Judge Gibbons from the Nevada Supreme Court said, no, as long as the judge in the particular case says that you got permission to file something, you could, because I was filing motions to disqualify. Because you judges, the chief judges, Gonzalez, Bell, you, before that, the chief judges were failing to follow, refusing to follow NRS 1.235. And I put an exhibit in here, which was a writ of mandamus issued back in January of 1987, where Judge Jansen, who now is 90, I'm 70, he's still on the bench as far as I know. I know they had a birthday party for me a couple weeks ago or so, or a few weeks ago. So, you know, he violated 1.235. I got the writ of mandamus from the district court, Judge Earl White, former Judge Earl White. And so I've been fighting this battle for years. This isn't something that, like you said in your answer to my disqualification, your order, that I manufactured. You know, I attached that exhibit of Leavitt in 2008, where she admitted that in this district, we have the chief judge. We had the chief judge or presiding judge hearing motions to disqualify. Well, that's totally at odds with the statute. It says it has to be heard by a judge agreed upon the parties, and if the parties are unable to agree, by a judge appointed. That's what they did one time in the underlying criminal case when they had Judge Gregory. Judge Gregory self-recused because he was on the Commission on Judicial Discipline, and Judge Wilson was then appointed in his stead. But all throughout, 1.235 was totally ignored. It's just flat hypocrisy. You judges are supposed to follow the law, and you refuse to follow it because you know that 9 times out of the 10, somebody's not going to review it, and you get away with it. It seems like the main rule that you follow is don't get caught. And now we have a different turn of events in Washington. That's why I filed now FBI complaints, because the evil and wicked Comey now is being brought to account in a criminal indictment for lying before Congress and then reaffirming his lie. And so there's a change in the atmosphere there in Washington, so I have some hope now. The ironic thing about this, I'll get to my other points here, but I wanted to stop on this one because this is not a frivolous thing. Judge Leavitt is effectively on probation because of the reprimand she received in 2015, which I attached to this the document as an exhibit. She was found not only violating Gina Dotson's rights on a contempt proceeding, treating it like it was a summary contempt when the alleged contempt was committed outside her presence. This is an absolute no-no, black letter law, that she can't do that. Didn't appoint an attorney, but then further exacerbating that, they did to the commission, and they decided this, that she failed to be honest. Now, if this was me, they would say, Mr. Blandino, you were lying. But because it's a judge and they still maintain that title as honorable, they use a euphemism like failed to be honest. No, she lied. If it was under oath, then it would be a lie under penalty of perjury, and she could be prosecuted for perjury, as Comey is now. But the thing is that because of that, I get retaliated against. The vexatious litigant order was based on Johnson, in part on Johnson and Hardcastle was chief judge at the time, because they weren't following 1.235. And when I filed a repeated thing, they just ignored it as per usual. So this isn't something manufactured because I suddenly have criminal charges levied against me in 2019. I realize I'm going into some of the merits, underlying merits, but you have to know the background on this. You have to have a foundation on this.
You're actually going into all the stuff, everything you said so far has been in your brief. So I've read it all.
That's not true. And I know you judges like to say that it's very cute and interesting, but this customer feedback is not there, so it's not everything. I did not present this.
Okay.
So could you correct the record? Please give me an apology. It's not everything.
I guess I will acknowledge that I don't remember seeing that.
You don't remember it because it wasn't there, Judge.
Mr. Blandino, you don't need to be.
Judge, I am righteously indignant. Look, you
Just
judges.
make your argument.
Yeah,
I'm
you
happy
judges
to-
are supposed to be enhancing confidence in the judiciary. But even coming into this courtroom now, and I pointed out to the marshal, you still got a sign on there, no cell phones, no nothing. That was here when this was the Nevada Supreme Court before they got their own building. Now, how does that provoke confidence when you can't even, as chief judge, say, you know, that doesn't apply anymore, please remove the sign? Did you even make such a request?
Didn't even know that there was a sign talking about cell phones on the door.
It's as big, if it was a snake, it would have bit you. Maybe you don't go out that way or come in.
I don't.
Okay, well then,
What
would
does
you
that have
please?
to do with you?
It has to do with this 3.026. Would you please address that as chief judge and take that sign off? That was not in these pleadings. I just noticed it this morning. Okay, the other thing I was asking for is establish and publish in the appropriate place the procedures for filing grievances in conjunction with the mandate of NRS 3.026. You could do it as an administrative order, which you have the power to do as chief judge, and just say, okay, according to 3.026, or you could publish it separately in some manner. I think administrative order is probably the best way to do it. So individuals or parties can follow procedures for filing grievances against their judge that does not address the merits. This is entirely reasonable and consistent with the legislature mandated. Admit that the 8th Judicial District Court did not follow NRS 1.235 prior to the change in statute in 2023, and assign the chief judge rather than the judge agreed upon by the parties. Now the parties, I may not have fleshed this out in total detail, but the parties in a motion to disqualify is a collateral action to the case. Everything now in case law says that once a motion to disqualify is filed, that judge must stop any further proceedings except for administrative thing, like the Judge Leavitt could say, I'm referring this to you. That's an administrative action, which she still has the power to do. And so everything's supposed to stop until that thing is resolved. In fact, Judge Bell disqualified herself because we had an unadjudicated motion to disqualify in my criminal case, but then proceeded to make rulings, even a competency determination. And I said I wanted a competency hearing, and she denied it. So that was a substantial judicial ruling that she made after she admitted she should be disqualified. So then, by a judge agreed upon by the parties, or if they are unable to agree, by a judge appointed. Now this was done, as I said, when Judge Gregory was assigned, and then he recused, and then Wilson was assigned to the case. But everything time thereafter, it was denied. 7, in the alternative to allow Kim to present more evidence to support what Kim has presented here, especially where Tom Newsom, the chief marshal, you know who that is, he said after my probation was done, and I went in there to test that, and sure enough, he got a complaint that I tried to go into Leavitt's courtroom, so I tested, just like Rosa Parks tested that law to get on that bus and refused to give her upper seat to a white man. I tested it, and I tried to get into Leavitt's courtroom, and Randy Hawks, with the approval of the judge, threw me out of there, and Newsom told me, you can go into any other courtroom in this building except Leavitt's. She had a restriction during the trial, after the trial, and then once I was put on probation, you can't go into any courtroom here or into the city of Las Vegas courtroom. And if I did, I could be found to have violated the probation or some other way, same thing. But she loses all power over me once that is done. So this is a clear criminal act. And so what Timothy Andrews did, he addressed this going forward, but this needs to be addressed backwards. Judge, you can have a talk with, as chief judge, you can have a talk with Leavitt and try to get an explanation, but if Tom Newsom were to be subpoenaed, this man is an honest, decent man. I've known him for many years. He's not going to lie on the bench, and he will corroborate that I was kept out of that courtroom. And Timothy Andrews said there's nothing presently, so he doesn't want to address and didn't address that. So therefore, 3.026 is entirely reasonable and proper in a situation like that, because that doesn't address the merits. I was coming into that courtroom to see if I could find further code violations by Judge Leavitt and possible criminal cases. In fact, not letting me come into the courtroom as an investigative journalist and an investigator, unpaid volunteer investigator, which means unofficial, for the Commission on Judicial Discipline, or working with the Commission on Judicial Discipline. I got 2 letters of caution, one against Judge Herndon when he called me an a-hole in court, saying the full word, which I don't repeat those words in polite society, especially where there are women around. And so I'm old school, so that's just the way I am. Don't use that kind of language in front of women. And so, and then against Judge Baer for doing a summary contempt proceeding for wasn't in his ocular review. The Nevada Supreme Court supported that, and they said, yeah, what Judge Baer did was illegal. At first, they didn't want to say that word illegal. Oh, it was problematic. So only on a petition for rehearing, they say, wait a minute, problematic, what does that mean? And then they reiterated or clarified that it was illegal. So Judge Baer received a letter of caution. I still yet to see those. I need to subpoena those in the underlying case. And then, of course, the catch-all as to the 7 items that I'm asking for, which were not disputed, and the alternative to grant such other and additional relief as is proper and just. And I would like to, I know you're going to deny me relief on any of these items. I did notice what you did with Judge Bluth's request for disqualification in this case that you had just the other day with Bob Luke, where she committed clear violation of the law by not following the contempt statutes. And I'm investigating all you judges of 8th Judicial District Court. You got judges routinely coming up onto the bench in a surprise thing. I'm standing here and I'm saying, wait a minute, DCR 18 requires if another judge is assigned to the case, you have to give a written request or written notice to, I think it's the chief judge, I'm not sure exactly on that, but they have to give written notice there. In any event, if you get a judge that's just jumping onto the case, if you've been in the federal courts, they'll say, if a judge is sick or something, the first thing they say is, I'm substituting in for this judge is sick. Either one of you have any objections to me sitting in on this case? And then, who knows? Somebody can come up and say, hey, you're married to my cousin or something. Oh, okay, then I'll disqualify. But none of these judges in this competency thing did that. You just jump on the bench and I'm supposed to just say, oh, okay, I accept that. It's flat ridiculous. I'm not given any time. I've got 10 days after a judge is assigned to file a motion to disqualify. But Judge Hardy, Judge Silva, and Judge Markey, respectively, and in different orders, there was a motion filed to disqualify. Judge Markey, I was given permission by Judge Leavitt in the case to file a motion to disqualify her, but because it was to disqualify her and all the 8 Judicial District Court judges, she denied it. I was later granted permission to file it. Judge Silva, while there was an outstanding motion to disqualify all of the 8 Judicial District Court judges, remanded me to jail so that I could get some psychologists that turned out weren't even certified. And because I objected to that, Judge Hardy said, oh, you're a danger to yourself and to the community, so I'm remanding you to Stein or Lakes Crossing, which has spent 3 weeks over there. But the point was that you just jump on the bench and it's like, oh, well, this is the assembly line. we're Laverne and Shirley, and we're putting on bottle caps. We can't pull this bottle out because you have a mind, a brain, and know what the law and the rules are. And so we're not going to stop for you. You're a bottle, we're putting the bottle cap on you, and that's it. And I know you've got docket pressures. All you judges have these docket pressures. But the fact is, you are supposed to be held to a higher standard by far than any other branch of this government, because you have to have the appearance of justice, not just be just, you have to have the appearance of it. And so this whole underlying habeas case, I mean, what's ironic, the ultimate issue, that's one of the points of the second amended complaint, is the fact that they did these things. That I was not allowed to file motions to disqualify against somebody jumped up on the bench. And in some cases, Judge Hardy's sitting up there with a nameplate for Linda Bell. So if somebody's back here there, and he wouldn't let me say a word. So if somebody's back in the audience, how do they make a complaint to the Commission on Judicial Discipline? Do they call them Linda Bell? Before they can even file a complaint, they have to do their own little ad hoc investigation to find out what the name of the judge is. So it's just flat ridiculous. I mean, you want to run this thing like an idiocracy. I don't know if you've seen that movie, Judge, but it's highly instructive. It's must-watching for this 21st century. So the whole thing is that I shouldn't have to file. The one point that must be stressed after everything's in, the only thing that was addressed in the response was the disqualification. And everything they cite is all old news. Never disputed, and I put that in my reply. They never disputed what I was asking for, that it was within your power to do. They never disputed any of the exhibits I attached. I authenticated them according to Federal Rule of Evidence 901 and the corresponding state rule that they were true and correct copies of what they were purported to be. And so when you have a situation where I have here, where they respond and they're talking about old stuff, these aren't bare facts. These are facts supported by exhibits. That 2008 minute order where Leavitt, said, no, in this district, we follow this. That's like a couple criminals. Well, in this case, we shoot the guy and then we ask questions later in a robbery. Why find out if he's got a bank account somewhere else? We'll just take his wallet. I mean, it's patently ridiculous. In this district, she wanted to be honest, which the Nevada Commission on Judicial Discipline already said she failed to be honest. She failed to be honest there and say, well, in this district, we don't really care what the law says, we're going to do it. And the biggest indictment to you and Judge Bell and Judge Gonzalez for failing to file and refusing to follow 1.235 is the fact that the Nevada Supreme Court changed that to comply with your illegality up until that point. So they did make legal now what you guys were illegally doing opposed to the legislature. And the only reason they did that is because I hammered that point 3 different times when I filed these petitions for an extraordinary writ up there. And I said, hey, they're not following 1.235. I don't get any credit for that. Not that I need the credit, but they didn't come to the legislature because they're given this status. Oh, if you say you need it, just like Elizabeth Gonzalez. She sent a letter to the legislature. It used to be you guys had 2 days to respond to a motion to disqualify with an affidavit. And she said, oh, it's not enough time, we're so busy. So they gave you 5 judicial days. And then you didn't even follow that. I saw Linda Bell make decisions in here because I was monitoring on her every Tuesday calendar up until I was indicted and then convicted. I was following her calendar all that time, and she had cases where an affidavit hadn't been filed against the judge, which means it was a mandated transfer, and the judge heard it on its merits. It's ridiculous. You have a complaint, and they fail to defend, and therefore, by default, it's got to be transferred to another court. What you don't understand and don't even seem to care about, any of you judges, is that while a motion to disqualify is pending, a person has no judge in their case. When Judge Ritchie wrongfully disqualified himself, and I attach that as an exhibit, and I had Judge Pepez from Ely assigned to my family court case, and they didn't have, smartphones and an internet. The files had to be faxed to them one at a time, on an old dinosaur-type fax machine now by the administrative office of the court. So I was caught between the devil and the deep blue sea. I had no judge. I had no one I was getting no visitation with my kids. So I had to file an emergency motion for mandamus. And because, in retrospect, I might have done it different. I asked Judge Pepez to stay any proceedings just because I was trying to be a nice guy and save him scarce judicial resources that he probably didn't have from Ely. I don't know what his docket load is, but I'm guessing it's probably pretty heavy with all the prisoners up there at the prison. So he granted the stay. I go up and I at the risk of antagonizing Judge Ritchie, who also is still on the bench. This is not coincidence. This is God stepping in and giving me signs that things are working in a way in which he approves of.
Okay, Mr. Blandino, I've given you a soapbox for more than a half hour.
But the point is, the one thing that I cannot leave here, I'm in form of pauperous. I want a transcript prepared, because once you deny me part or all of the relief, I don't think you're going to give me anything based on your demeanor and your deportment. I'm going to have to file an emergency petition to the Nevada Supreme Court, at the least, requiring you to follow and set up those procedures 3.206, 3.026, because I have no speedy or adequate remedy. If you deny me, I can't appeal it. So the only thing that's going to lie is mandamus, prohibition, certiorari, or an original habeas, which that's out of the question probably. But the point is that I need a transcript. If you want me to prepare the order, which I did for Leavitt in the lower court, I'm going to need to take this up right away. And the problem is, really kind of riles me a little bit. You don't see this as an emergency. I'm 70 years old. I'm in pretty good health. I don't see doctors. I take my blood pressure medicine and that's it. But God has blessed me with some pretty good health. But the thing is, I can't wait 30 years like Rippo and Echeverria waited. I've got to go to the Nevada Supreme Court, because I've got to show that you guys are refusing to follow Rippo. It's Nevada U.S. Supreme Court precedent. You in your thing laughably said, I don't see the actual bias from Leavitt. It isn't about actual bias. The Nevada U.S. Supreme Court said the risk of bias. If this isn't the risk of bias, then Rippo and Echeverria, they would still be getting nothing from the federal court. So I'm going to ask, I've got the federal habeas on abeyance and a stay in that case. Now it's going to be rare because the Ninth Circuit doesn't like the rule on futility. But I'm going to say, look, Judge Wiese wants to ignore the law. The Nevada Supreme Court wants to ignore the law. They just want to do whatever the heck they want to do. They want to legislate from the bench. It's futile to do this and go through this process. And they're hoping, for God's sake, you're not one of the ones that are hoping that I die before this procedure and then it'll be all rendered moot. And there are a couple of things that I must stress. Judge Leavitt said I was not prosecuting the petition. I showed Schwartzer, Attorney Schwartzer here. I'm prosecuting 2 appeals at the Ninth Circuit. In the docket notice and everything, they tell me that if I don't follow through, it will be dismissed for failure to prosecute under Rule 42-1 of the Ninth Circuit rules. I am petitioning this court, but I am prosecuting the action, is the correct way to say it. Former Judge Ed Reed of the U.S. District Court has that same language in a case. And Judge Leavitt said, you're not prosecuting. I mean, it's a joke. If you saw the video, well, you read the transcript that was attached. he refused to go from the plaintiff table. I'm the plaintiff or petitioner. I'm the moving party. I'm the initiating party, both in the underlying habeas action and in this collateral thing, the motion under 3.026. I'm the initiating party. Schwartzer and the DAs could have filed their own motion to disqualify Leavitt for whatever reasons. And then they'd be the initiating party in this action. So, you know, if I give you all difference, you took over as chief judge and you were just doing what everybody else was doing. But the scripture says, you shall not follow a multitude to do evil. And clear violations of mandated law that they had. I mean, understand, Judge, you're in the 8th Judicial District. There's districts throughout this state where they only have one judge. So if you file a motion to disqualify, and you know, I don't know how the population actually went over the decades in the whole state, but where there's only one judge, you file a motion to disqualify, he can't do anything else. They've got an alternative but to ask for a judge appointed, you know, if they don't want to rule on it, but still, even to hear that motion to disqualify, they have to get a judge from another district. So you ask the Nevada Supreme Court administratively to say, hey, we got a motion to disqualify here, we got one judge, you got to appoint another judge. But for some reason, you want to treat this presumption that the judge is unbiased and that there's no risk of bias like it's some concrete wall that you can't rebut it no matter what you do. Because I'm not seeing many of these things granted. But, you know, you have an obligation under 3.026. You have the AJDCR 1.30. And for the love of God, Judge, just order that this thing be transferred. I haven't yet been able to have discovery in Ripple and Echeverria. The whole problem that took so long is because their knowledge was being hidden from them. I have every reason to believe the FBI is investigating this. I'm going to do my best to see if they investigate the whole lot of it. But for God's sake, just let me continue with my petition by giving me a judge from another part of the district where there is no risk of bias. You use the expression all the time, well, I'm going to err on the side of caution and therefore I'm going to do this. Err on that side of caution and give me a district court judge from another district. And then follow the law, for gosh sakes. You know, this was not in the papers. In Nevada, unlike any other state, you have to swear an oath to the Constitution of the United States and to the government of the United States and to the state constitution of Nevada and to the government of Nevada. You're violating that oath because the government of Nevada said 3.026, you got to establish those procedures. 1.235 was the government, the legislature with a signature of the governor that passed law said, no, this is the way you want to do it. But you know, in this world, that you can get away with a lot of things without getting caught. And the final rule cannot be that, well, we're going to do this as long as we don't get caught, and then if we do, well, like Erica Ballou, her appeal's going to go nowhere there. She's going to be suspended, and she's just wasting a lot of money because you can't say to the Nevada Supreme Court, well, I'm not going to follow what you do, and I'm not going to follow the law. That's so clear-cut, they can't ignore it. But this, apparently, you've been getting away with it through decades, so, you know, Thomas More in that great movie, A Man for All Seasons, just because something is common doesn't mean it can't be illegal. It's common you can go into Walgreens and see a guy filling up trash bags full of merchandise and taking it away. I stopped one of those guys, had it in his hands. I'm thinking to myself, why does this guy have a bag? Go into the store, and I said, did that guy just steal that stuff? Yeah, he did, but we can't do anything. I said, I can. So I walked down the aisle, I grabbed every item, and took it back in the store. I couldn't grab everything because he had it so full. It was ice cream and beers. And they took it back into the store. You say, what business is that of mine? He's stealing from me. Because they have to raise their prices, and if they have to raise their prices, that means I'm paying a penny or more for every item. It is my business. We can't live in a situation where the judges become criminal just like the people they're sentencing. How many times have
I'm
you...
going to cut you off, Mr. Blandino.
Will I get that
appreciate your
transcript?
argument, but I've let you go for about 40 minutes now. You've made a good show for Mr. Falcone's show.
Alex here. We'll talk about this at the end of the video. Chief Judge Wiese makes a good point.
We'll let Mr. Schwartzer
I object to that
talk.
comment. I'm not here for show. I'm here to get relief.
Okay.
I object. Could you apologize for that remark? That makes it sound like I'm a showman, like I'm Barnum and Bailey.
That's what it seems like.
I object. You think so? I object to that. You apologize now. I'm going to file a complaint with the Commission on Judicial Discipline.
I don't know what you need to file, but would you sit down and let Mr. Schwartzer make his argument?
I can't remain standing?
You can.
Okay, thank you.
All right, not much. Despite what Mr. Blandino said, I think we did oppose what he wrote in opposition. I'm sitting here listening to these 45 minutes of him speaking, and he's constantly talking about things that don't really matter to the issue at hand, whether Judge Leavitt has a bias or not. First off, I don't see any affidavit that's actually been filed upon Judge Leavitt, which is required by the rules from someone who seems to be talking a lot about rules. Additionally, he keeps talking about 3.2, what were you saying, NRS 3. What?
1.235.
Okay. So, what I'm seeing, well, I think that confuses it with the 1.235, but what I'm seeing when you look at the statute itself, he's saying stuff like, it needs to be agreed upon the parties for the new judge. That's not actually in the statute.
It was in the old statute.
It's not in the statute, I'm talking, thank you. It's not, so it's not in the statute, so it's not law. He talks about, he kept referring to another NRS statute that doesn't exist. The 3.26, whatever he was saying before, he said it over and over again, I kept checking, that statute doesn't exist. So, I understand he takes little bits and pieces from here and there, and like tries to make it into an argument, but at the end of the day, it falls apart when you look at everything. Mr. Blandino was upset that we keep quoting previous hearings, but in the court of law, that's what we do. The law of a case applies. So that's how law works. And here we've had this issue before. It's been brought in front of you before, Your Honor, and you've had this ruling here before. I understand he disagrees with it. I understand he's going to take this up to the Supreme Court. But it's not just us bringing up old hearings. It's part of what we do in a court of law. What I've only heard for these last 45 minutes is spurious allegations against the court that lack any type of foundation. The state does not concede that Judge Leavitt is biased. We disagree that, and you can see that in our opposition. And Your Honor, I would ask you to review our opposition where we address what we can from his points, where we address it directly on using case law that hasn't been superseded by statute, case law that addresses the current statutes, and then shows that in this case, his motion should be denied. Unless you have any further questions, Your Honor, I don't think there's much else I need to say.
And I'd like to rebut.
Go ahead, I'll give you about 5 minutes.
I mean, it's ludicrous what he's saying. This is the law of the case. These exhibits are stuff that I didn't have access or privy to before. When that COA issued, or the Court of Appeals issued their rulings and stuff that he's relying on, that does not mean that Judge Leavitt, he somehow seems, it's like some kind of cloak from Harry Potter of invisibility to where they can hide behind this cloak and nothing can pierce it because you don't even know it's there. The fact is that these documents I didn't have knowledge of when the original motion to disqualify, specifically that request for evaluation, which shows that Judge Leavitt abandoned her judicial role and became an advocate for me and signed. I didn't have those. I had the one part of that document, but on getting the left side of the file, which Judge Leavitt did graciously grant access to, it shows that it's a 3-part form on the left side of that file. Did you look at that form, Judge?
I know what the competency form looks like.
Yeah. Well, I don't know if you maintained that what Linda Bell had in 2016 when she was chief judge, it said, request for competency referral will not be granted unless counsel does this and that. You saw that? So Judge Leavitt, using the form, admitted that she was counsel for me, thereby abandoning that judicial role for even if it was just 2 seconds, and then she jumped back into the case to sign the bottom of the form. You can't sign the top and the bottom of the form. It would be like a mortgage loan officer signing an application for a mortgage loan and then approving of her own loan. There's no way in banking parlance that would, and to have a judge do it, if she wanted to do a referral, she didn't have to use the form. But by using the form, she was tied to what it said. Now, she could have scratched off that counsel. You know the page I'm referring to? I'm trying to find it right now. So it's clear. And then it said it won't be granted unless they provided the email and the phone number there. And so she just put the phone number but not an email on that corresponding form. Now, I know the federal court because I've seen the federal court case law on this type of thing here. There is no way that it could be construed, and it doesn't matter for how long it was. And the judge, on the transcript, in the transcript, she said, well, I signed that form because I'm not an expert, so we need an expert. No, the Dusky versus U.S. is very clear, is that the judge has to find that the person, or at least observe that there's doubt about whether he understands the nature of the proceedings, or the adversary nature of the proceedings, or doesn't understand the process. I survived 2 phoretic ambuses, one in the Justice Court and then one at the District Court, and I elaborated on those questions. I know all the rules, the federal rules of appellate procedure, Nevada rules of civil procedure, criminal procedure, all of that. I've been to the federal courts many times, been to the Ninth Circuit, been docketed in the U.S. Supreme Court 4 times. I filed an amicus brief, they received it, in Trump Travel Ban 1 at the Ninth Circuit. You can look on the internet and find that document. I've done numerous probates in there, one for a guy that was in prison. Judge only had to ask questions. If I could be found to have doubt about my competency, the judge only had to ask questions. But the final cherry on top, Judge, is the fact that she said I had doubts about your competency, but did not revoke or suspend my right to represent myself. Therefore, when I went before Judge Hardy later on, Ben was still standby counsel. He was reticent to say anything. So just like in the Gina Dotson case where she said, well, to herself, I don't need to appoint counsel because I'm a judge, so I'll just find her in contempt. The music plays on. And so it's flat ridiculous because she knew. All she had to do was ask the questions. I'm not an expert, she says. You have to make that threshold determination. All she could have to do was say, Kim, do you understand what the defense or the prosecutor is doing in this case? Do you understand what his role is? Do you understand this? Do you understand that? Because it was a complete joke to refer me to competency. But the one who initiated it was the district attorney. They wanted to kick the ball down the road, maybe hope they could get this case off their books, then spend some years or something, who knows, in Lakes Crossing. Maybe entice me to be a malingerer and pretend that I didn't understand. And then, but the point is, he only focuses on the Leavitt thing. You notice he didn't address any way whatsoever in the response about what I was asking for under 3.026. None of that was disputed. You have obligations under law under 3.026. They didn't address, and even now in his oral argument, he didn't dispute the relief I have asked for, or that you have the power to grant it under 3.026. As a human being, for God's sakes, you can admit to error and say, Mr. Blandino, I'm going to give you this and this and this relief. But I see nothing coming from you. I may fall down, drop dead, or faint if you do give me something in response. Maybe you won't even let me have the transcript. But the thing is that I tried to get 3.026 in that one exhibit you showed from Linda Bell to establish those procedures. Refused to do so. And to this day, you don't have any procedures. Those customer feedback things that Gonzalez said was a joke. So all I'm asking is what the statute demands, that you have procedures, you can discipline. He doesn't address anything about me keeping me out of the courtroom, as that was proper or not. It was not overcrowded. There was none of those issues. Tom Newsom, at the very least, Judge, I demand that you have an evidentiary hearing. I get to subpoena Tom Newsom here and find out, because now this is spreading like a virus. Amy Wilson kept me out of her courtroom, and I filed a complaint down there with the chief judge, and it's gone to Joe Tomasino, who's staff counsel for the Justice Court. I found out from Steve Sanson's Veterans in Politics that they were kept out of Amy Wilson's courtroom. This is turning into a jungle and a type of kangaroo court where you judges you make it up as you go along in some cases. And keeping somebody out of the courtroom that wants to watch, the bailiff said, well, you got to give me a case number. I said, I'm not here to watch cases. I'm here to watch judges. And then you step in a noose and say, well, you made a good show for the cameras. You are supposed to act as though those cameras really are inconsequential, but you made them consequential. So I'm going to ask you a second time. I'm going to give you a second bite at the apple. Will you apologize for that remark where you said you made a good show for the camera?
Mr. Blandino, I listened to your arguments.
You're not going to apologize, Judge?
Now we're now.
You're not going to apologize? You're not going to
I
apologize?
apologize to you, no.
Okay. Then we'll see what the commission has to say about that. Now, under 3.026, this raises another issue. I have a complaint, not related to the merits, but about that comment. Where do I make a complaint under 3.026 about you? What procedures have you?
I'm not going to do this today.
So I have nowhere to go to complain with you except for the Commission on Judicial Discipline.
I'm not going to get sucked into your little thing that you're doing here today.
The little?
I will.
Did you say little?
This
Did you use the word little, Judge?
show that you're doing. I'm not.
This show. Okay, so now you're doubling down on show.
Mr. Blandino, the hearing's over. I will issue an order.
Can I get you to orally grant that I can get that transcript so I can go to the Nevada Supreme Court right away?
I don't have a problem giving
Do you want me to prepare a written order, or you just, okay.
No.
Well, I thank you for that. And I'm not saying that for show.
Okay.
I sincerely thank you for that.
You bet. Have a great day, guys.
Thank you, Arthur.
You too, Judge.
Alex here. In response to Chief Judge Wiese's remarks, I just wanted to make it clear that our Nevada judges does not encourage litigants to conduct themselves the way that Mr. Blandino does. Sometimes litigants make it seem like they are aligned with ONJ, but ONJ does not align with litigants. To a judge, it might seem like the best way to discourage these litigants is for ONJ to cancel camera coverage and deny them publicity, but this runs afoul of our purpose as well as our serial coverage model. ONJ does take deliberate steps to discourage misconduct, for example, declining to cover new cases involving the litigant. In extreme situations, we've even edited footage to remove abuse of the camera. For example, we've had situations where a lawyer turns to face the camera and thumbs up, and we've had a situation where a litigant turned to face the camera and tore a court order apart. The nonprofit corporation emphasizes showing the public myriad types of cases, and this sometimes includes difficult cases that show the public the unique challenges our judges face. If we were looking to amplify misconduct, publication would look very different. For example, litigants would be given studio interviews, or their other cases would get camera coverage. I suppose if anybody has any other questions, feel free to post them down in the comments below, and I'll address them if I can do that. Thank you.